At the outset, it is required to be noted that as such there are concurrent findings of facts recorded by all the courts below on the readiness and willingness of the plaintiff to perform his part of the contract, which are not required to be interfered with by this court in excess of powers under Article 136 of the Constitution of India. However, at the same time, what is required to be considered is whether, in the facts and circumstances of the case, the High Court is justified in overturning the judgment of the learned trial court as well as the First Appellate Court refusing to pass the decree for specific performance of the sale agreement. At the outset, it is required to be noted that, as such, while allowing the second appeal and overturning the judgment and order passed by the learned trial court as well as the First Appellate Court, the High Court has not framed the substantial question of law which is required to be framed under Section 100 of the CPC. Even otherwise, on merits, also looking to the terms and conditions stipulated in the sale agreement, the High Court has erred in passing the decree for specific performance, which are refused by the learned trial court as well as the First Appellate Court. The relevant clause in the sale agreement reads as under. Thus, as per clause 2 of the sale agreement, if the second party fails to pay the balance amount within stipulated time, the advance will be forfeited, and if the seller fail or refuse to execute the sale deed and other necessary document in favor of the purchaser/buyer or in the name of his nominees within the stipulated time, the seller will be responsible to pay double the amount given as an advance. Therefore, on failure on the part of the seller to execute the sale deed within the stipulated time, the purchaser/buyer shall be entitled to the double of the amount given as an advance. It cannot be disputed that the plaintiff, being a party to the agreement to sell, is bound by the terms and conditions stipulated in the sale agreement. Therefore, on true interpretation of clause 2 of the sale agreement, the learned trial court as well as the First Appellate Court as such rightly refused to pass the decree for specific performance of the sale agreement and rightly passed the decree for recovery of rupees 4 lakhs, being double the amount given as an advance, which has such was in consonance with the clause 2 of the sale agreement. As an identical question came to be considered by this court, and after considering the earlier decision of this court observed and held that the sum named is an amount the payment of which may be substituted for the performance of the act